Okay, good afternoon, everyone. It's 4 past 12 in the afternoon. Thank you for joining us today. My name is Jacqueline, and I'm the Director of Sales of No Borders Law Group. And on behalf of No Borders Law Group, I would welcome you to today's webinar. So for today's webinar, we will be focusing on visa refusals, court appeals, and the law. Before we start, I just want to give you a background of the company. Okay, so No Borders Law Group has been helping individuals, families, and businesses navigate Australian legal and migration matters since 1998. We provide services across migration law, employment law, property law, and commercial law, delivering practical advice and tailored solutions to help the clients move forward with confidence. So, in today's topic, what we're going to cover today is the refusal landscape right now. As we all know, the subclass 407 training visa has always been a closely scrutinized visa category. Given its intended purpose of facilitating genuine workplace-based training and professional development rather than an ongoing employment. So a recent article published by Australian Border Force last 26th of May 2026 provide an interesting insight into the government current compliance focus with the launch of a national operation targeting non-genuine training um, rather than employing a migrant workers. So the topic that we're going to discuss today is about the tribunal, what merits review in practice, and that's going to be covered by the CEO, founder of No Borders Law Group, Agnes Jimenez. The next one is a court proceedings. What is judicial review look like? And this is something that we're going to explain it. This part will be explained by our director and also the principal lawyer, Heinz Lapaje. And the last one that we're going to talk about is we're going to give you some indication of what the real cases look like and what success we have been through all out of these services that we've got. So, EJ, could you please go to the next slide? Okay, so let me introduce to you Mrs. Agnes Jimenez, the group CEO and the founder of No Borders Law Group. Okay, next one. Okay, so before I hand over to Agnes, just a housekeeping rule. So we would like to encourage everybody to provide us with some questions and submit them through QA and chat. Okay, and we will address them during the webinar or at the end of the session. Okay, so without a further ado, let me introduce Mrs. Agnes Jimenez, who's going to be the first speaker today. Over to you, Agnes.
Thank you so much, Jackie, and welcome everybody. Thank you for attending this meeting. We thought it is very important to share our knowledge and experience, mostly with you guys as migration agents. As you are aware, I started my practice in 1998 as a registered migration agent and became a lawyer in 2004. So I am very passionate about, taking matters to the tribunal or representing the clients at court. Why we don't have that many court appeals, because that's a very expensive exercise for the clients. We certainly have done hundreds of tribunal matters in our practice throughout the years. So maybe our heading is a little bit different, or I would start a little bit differently. So when we receive a decision from the department regarding refusals, okay, the very first thing is we have to check if the decision is reviewable. In recent times, you become aware that many 407 visas have been refused and the nomination was not approved and the sponsorship was not approved. Therefore, the visa applicant could not appear. Or sometimes you get a student visa refusal from overseas and the department puts in, okay, the visa applicant has a right to appear within 28 days with the ART, but the next page is stating if the applicant was offshore, there is no review rights. So it's very important that us as practitioners reading the refusal, that's the very first thing. Usually the department gives pretty good guidelines, when to appear, how many days the visa applicant has to appear, and you have to check who is going to appear. Is the visa applicant or is the sponsor? So very, very important always to check, the decision record from the department and the refusal letter. As you know, in recent times, the AAT become the ART, and, it's throughout the years, throughout the last 30 years almost, there are so many changes with the tribunal. And what I have observed in recent times that they changed the time limit to appeal, okay? Overseas appeal as well is still 28 days. If you remember in old times, you had, I believe, 72 days because you had 60 days to appear, but also you had postage time to appear. So it was about 72 days. And now they all brought back to 28 days. So it doesn't matter the applicant is offshore, the appeal time is still 28 days. Also, what they have changed, any cancellation is now 14 days. Previously, they had 5 working days, and you could extend that by another 5 working days. But now is a general rule, 14 days to appeal against cancellation. Different rules applies if the applicant is in detention center. What is important is the deadline. So if you miss the deadline to appear to the tribunal because you missed the 28 days, the tribunal would not review the decision. This is extremely important, okay? The other very important deadlines with the tribunal appeals is providing documents to the tribunal. So when you lodge the appeal, there are questionnaires sent to you by the tribunal and asking you to provide who is going to attend, what documentation you would provide. And if you miss that deadline, the tribunal comes back to you and they may not going to proceed to a full tribunal hearing. You might have been given an opportunity to provide written submission and represent your client based on the written submission. It means that the client loses the right to present his or her case directly to the tribunal. So it's very, very important that you look at that, checklist, what they're sending to you. Also, the very important thing is to meet the deadline regarding the hearing. Okay, so you can seek an extension of time if you might overseas, or the visa applicant got sick, or someone or yourself has to attend a conference or a meeting, or you have another hearing on the same day. There are different attributes or different situations where you can seek the tribunal for an extension of time, but certainly you need to seek that extension well before the hearing deadline. Okay, so these are the key aspects of the tribunal appeal and the deadlines what we need to meet. All right. The other very important issue is, and we are providing that as an attachment to our slide presentation, that you look at Part 5 of the Migration Act and check who is the applicant for the review. Okay, that is very, very important. And Part 5, Section 338 prescribes all the different requirements who can lodge the application and under what, and I'm sure as migration agents and legal representatives, you have read this section in the Migration Act, and you are familiar with that. That prescribes where the applicant was when the decision was made. Was the applicant in a migration clearance? Was the applicant in the migration zone? Or is the sponsor who has the right to appear because the visa applicant in offshore? So that is something very, very, so these are the key elements when you appear to the tribunal. Okay, so the issue is, and I think we may have a question. Am I correct, Jackie? There was a question here.
Yes, that's right, Agnes.
Yeah, can you?
Yeah, so they're actually talking about RRV visa refusal offshore with no blood relative in Australia. Arun is asking what are the options?
Yes, we would come to that when we have a court appeal, okay? Because if a person is overseas and they have no sponsors and no relatives in Australia, and a refugee visa was refused, or any visa which the applicant was also, it can be a skilled visa as well, and there is no sponsor in Australia, then the only option to review the decision is an originating application at the court. So, and also the deadline for that is 35 days. There is no tribunal appeal available. There is no sponsor and the applicant is offshore. So just remember that, and that's relevant to all other offshore applications. The court in Australia has the right under the Constitution to review the decision of the executives in any situation. So therefore, you can, in some cases, say, for example, we had a permanent resident visa, okay, that had to be reviewed in Australia in a court, and maybe that is relevant to the refugee visa application as well, that any permanent resident visa application can be reviewed by the High Court of Australia. So we had a matter where our barrister represented a client regarding a 132 visa application. And can you just go back to the previous slide? We are not finished with the previous slide. So I'm just answering the question. So there is only a high court which can review offshore permanent visa refusals. So we had a 132 visa refuse, not us, but another applicant, and our barrister represented them at the court, and it was only an originating application at the High Court of Australia. Okay. Any other questions, Jackie?
No, that's all good. I think, Arun, that's gonna be very informative. I hope we able to answer your question.
Yes.
Yeah,
Okay.
thank you, Agnes.
So these are the ART applications, as I mentioned. So you have Part 5, Section 338 of the Migration Act, okay? There is also, you know, a tribunal manual, which we can all have a look, and, you know, certain procedures, what they can, you know, what we or, you know, the applicant has to follow. They prescribe that in their internal manual. But really, we have to follow what is in the Migration Act. Very important that the correct fee has to be paid at the time of the application. If the visa applicant doesn't have the relevant funds for the application, then the visa applicant can seek a reduced fee or not to pay any fee. As you know, the RRV refusal, the refugee review appeal, usually doesn't cost anything at the time of the application, and at the end they have to pay the full fee. I don't know what is the fee at the moment for the RRV appeal. It used to be $1,000. That may have changed just in, you know, on 1st of July. So I won't be able to tell you that, but you can have a look at it on the ART website. But usually there is no fee at the time of the application when you're lodging a refugee review appeal. Also, the citizenship application appeal attracts some, when someone's citizenship application is refused, attracts a fee that is about $1,150 something, and the current fees for the ART appeal is $3,700 or so. I think 3,727. You know, you just can't remember always the changes of the fees exactly. But also remember, when you win your matter at the tribunal, 50% of the fee is always refundable to the client, and you know, you don't get any, I mean, you charge the client the fee to represent them at the tribunal, so there is no refund for your legal fee, but the tribunal makes the refund of 50%. So these are the initial steps and the initial issues regarding the tribunal appeal. Now, I probably would pass it on to you, Heinz, just talk about the court appeal and what is required for a court appeal initially.
Thank you, Agnes. And just listening to Agnes talk about the tribunal and the various options available under that, it's a wealth of knowledge that she holds. So for those agents out there, it's something you should avail yourself of. My name's Heinz. I've been with the firm now for some months, and it's my pleasure to talk to you about the legal aspect of review and judicial review. I'm a senior lawyer, and I've had the pleasure of doing a lot of work in courts on behalf of clients, which I enjoy because it is kind of the cutting edge where you can see you can directly see the results of and outcomes of the work that you're doing on behalf of your clients. Courts can be slow, but when you're actually in a hearing and you're getting the judgment, that's where the rubber really hits the road, and you can see that you're achieving some outcomes for your clients. With judicial review, it is a very, and we should all remember, it is a very narrow area of activity for the court in respect of reviewing these decisions that come through the tribunal. The court is only interested in looking at an error of law. It's not really interested in relitigating on appeal all the merits of the dispute itself. So the court really has to establish, in looking at an appeal against a review decision, two factors. One is that there has actually been an error that has occurred, that has taken place. And then the second is that error still has to be material. And it has to be material enough to potentially affect the outcome of the decision. So if an error has been made that is immaterial, that is, it is of a nature where it wouldn't have affected the outcome, notwithstanding the fact that it's an error, then it won't be a material error and it won't trigger the intervention of the court to judicially review the decision. And materiality is is a matter that would be argued in these cases. And what the court is looking at in establishing is not if, absent the error, a different decision would have been made, but rather whether a different decision could realistically have been made. So if the court is convinced that there's a jurisdictional error, an error in law, and that it's material to the point where a different decision could realistically have been made, then it will allow that appeal, and there will be a successful outcome there. And what that means is not that the court then relitigates the entire matter. The court simply remits the matter back to the tribunal and asks them to, as a result of the appeal, to look at that decision again. So that is the nature of judicial review of these decisions available to the federal court. As I said, it's narrow, but it's still very important because it gives oversight and makes sure that legal standards are upheld so that there's some consistency in decision making and that all decision making is ultimately held to be lawful. Agnes, is there anything that you'd like to add or that I might have missed, or are you comfortable with that?
No, I'm comfortable with that, except, if you can talk about, I believe the fees is now around $5,000 to make, to appear the court.
Yeah.
You just can elaborate a little bit.
The court fees are what they are, and they are substantial. They're designed, obviously, to cover the court's costs, but they're also designed really to test, I think, and this is true of all courts who charge fees, and they all do. They really they're not interested in cases where people are, if you're like rolling the dice because they just want to try and change the decision. They want to know that the applicants in matters have a stake in it. They've got some skin in the game, that they think that the error is serious enough to actually spend the money on that appeal, that there is a real case to answer, rather than just simply open the floodgates and everyone who doesn't like a review decision then appeals because it's free. So as Agnes says, the court fees are about $5,000, and regrettably they're not remitted upon successful outcomes. The court will hold those fees because they are the court's fees. The only relief you might get is, of course, that there might be some cost recovery against the other side if there's a case for costs, but again, not easy in this jurisdiction where you're dealing with tribunal decisions and potentially an actor on the other side who's an agency or some element of government. But you are tested in a sense as an applicant by being asked to put, as I said, some skin in the game, and that's about $5,000. But given the stakes that are being argued, there would be many people that would say that that's a reasonable investment to make given what's at stake. So it is what it is. Agnes will tell you there are fees all the way through the migration process at many different points in very many different agencies and at very different levels. That's a government issue. Don't blame the lawyers for that. But they are effectively regulatory fees.
Yeah, and based on our experience, we have, cost assessed against the Department of Home Affairs quite substantially. So sometimes, the visa applicant can recover $20,000, $30,000, depends how much they fee. Like we have clients at court where there was initially the federal court, then it was the full federal court, and the full federal court made the final decision and remitted back to the tribunal the decision. So, you can appreciate how much time went into these applications and how much work by the barristers, by the lawyers, and the client was awarded around $50,000. So yes, the case will be assessed. Is not like, that the tribunal refund 50%, that the system is quite rigorous and they assessing all the time. Therefore, it is very important that the representative who represent your clients at the court keeps proper file notes, proper information, because based on those informations, the assessment to cost can be provided to the cost assessor and the client can receive the fund, which is very beneficial because they get in the permanent residency and also they get in the money, okay? Mind you, the client initially pays that money out, okay? So just briefly coming back to the slide, very important, and I'm sure you all know that migration agents, registered migration agents cannot represent clients at the court, so you require a lawyer or a barrister to represent your clients at the court. That's just the court procedure, okay? So the next slide, please. And with that, okay, once again, just talk about the merits review here. As you are all aware, the procedures for the tribunal hearing is that the department will provide the documentation, the whole material to the tribunal, and the tribunal will examine those documentation. That's their evidence in a sense. At the time of the application, you do not require to provide any documentation regarding evidence. The requirement is only the decision record and the cover letter, usually which states that your visa has been refused. These are the two documentation what is required at the time of the application, and later on you can collect your evidence. Now, as you are all aware, the tribunal has a huge backlog, sometimes a year, depends if it's temporary visa, sometimes 3 years if it's a permanent visa. And during that time, you can, prepare your application. Unfortunately, if a student visa application is refused, then sometimes you have the difficulty that the student may finish their studies in a process and they would need to reapply for another student visa, or not a student visa, but reapply for another confirmation of enrollment and enroll in a further course because the tribunal still hasn't made a decision. These days, the tribunal is actually providing opportunity to prepare submissions, which you as agents can certainly facilitate. It is extremely important that you prepare applications or submit, it's a tribunal application, but you prepare the submission very well, taking all the evidence available and doing advocacy work for the client. So it's not just that the client is providing you evidence, but you are able to seek information, you really investigating the situation and sort of guide the visa applicant to the right outcome, which means that you can obtain further evidence, not just what the client initially presented to you, or not just the initial evidence what has been provided to the Department of Home Affairs. Very, very important these days to prepare these submissions well, because that can help your clients to get the decision on paper, and the client doesn't require to attend any hearing. As I said before, if you miss a deadline or you have any issues with the tribunal, it's always very beneficial to prepare a very good submission, send it off to the tribunal until they make the decision. Once they make that decision, you cannot submit further evidence. You only have the right to take the matter to the court. So that's something very important, especially under the new approach, that they can make a decision on paper. Otherwise, you have the hearing and you have to guide. I always say guide and coach your client how to appear at the tribunal. My recommendation, based on my 30 years experience, as lesser people, witnesses attending the hearing is probably better. I mean, if you have key witnesses, certainly they have to attend, but as lesser people attending the hearing, or people talk less at the tribunal, just really focusing on the issues in hand, that is always more beneficial. As probably all of you are fully aware that when you are at the tribunal hearing, the members are always asking, and do you have any further question? And would you like to share other information with the tribunal? Sometimes our client can shoot themselves in the foot because they start to talking about something which is irrelevant, but maybe the tribunal start to asking questions, or the tribunal members start to asking questions, and they're getting confused and they can lose a positive outcome. So it's very important in tribunal hearings to really guide and coach your clients how to behave in a hearing, okay? Say I had a client, in the past who, we represented, he was from Vietnam, and he actually started to crying and screaming at the tribunal that he's doing so many good things for Vietnam and he's sending money back to Vietnam, and he was crying. And so the tribunal member had to actually call security and vote him out, and we lost the tribunal appeal. So it is very, very important to ensure that your clients is coached before the hearing. And I actually told this particular clients, because they were husband and wife, I told them that I don't want him to attend the hearing. But the family said, no, he has to attend the hearing. So as a representative, you act on the instructions of the clients. So we couldn't not to have him in the hearing. But it's very important to prepare the client in the right way. As you are all aware, the tribunal can affirm the decision. The tribunal also can make a decision to set aside, and the tribunal can remit the decision back to the Department of Home Affairs. The key aspect of this is the tribunal set aside the decision, the decision goes back to the department and they grant a visa or approve the sponsorship and the nomination. If it's remitted back to the Department of Home Affairs for further consideration, this can be like, if you have a partner's visa subclass 820 or 309, and the tribunal established that there is a genuine relationship, marital or de facto relationship, and the visa should be approved and goes back for further consideration, which means probably having secondary applicants, having character issues, or having medical so the applicants would need to do this test again. All right. Now, if the visa applicant if the visa applicant during the process of the ART appeal may have been involved in some criminal activities or developed cancer during the process, then that can affect again the outcome of the decision. So this is why it's important that the tribunal remits the matter back based on the issue on hand. But then for further consideration for these issues, the department can request the further information. If the applicant passes all the requirements, then of course they have to grant the visa. If there are other considerations, then certainly they can refuse the application again. And we have issues like that in the past. So it is very important that you advise the client that, if they have any character issues, they should, mention that to you upfront and not at the end of the decision. Heinz, anything mentioned about the judicial review, please?
So I neglected to mention earlier, and Agnes covered me, so thank you, about lawyers only appearing in the court. So unfortunately, agents can't appear. It's lawyers only, so it's by representation. There's a 35-day deadline from the migration decision to make that appeal. If you're later than 35 days, you have to seek some kind of right to appear by getting an extension, but they're very difficult to get. So strong advice is get your appeal in early, pay the court fees on time. Otherwise, there might be a problem getting access. I did mention earlier about legal error, jurisdictional error, natural justice, and this issue of materiality, and that all applies. And just remember again, this is not a review of the merits of the case. This is not a review of the actual meat and potatoes of the case that you're involved in. It's really just, has there been an error? Prove that error and then have that matter sent back to the tribunal for it to be re-examined and hopefully corrected. And that's the nature of judicial review. Agnes, I think that without getting into the weeds on anything else.
Yes, and if you just can maybe share some information, what is amounting to jurisdictional error and natural justice?
And what, sorry, justice?
Natural justice.
Oh, natural justice. So natural justice is making sure that people's material that people have submitted is taken into account in the process of the decision making, and that it isn't ignored, so that they are, that the basic principle of natural justice is that people have a right to be heard, and they're heard by obviously the submissions they make, but in our jurisdictions, in the way that we work, sometimes our submissions are in writing. So submissions include your materials, so documents and all related material that is in front of a tribunal, all have to be given fair treatment. And the error of law that we're looking for might be as simple as failure to submit a proper document, failure to consider a proper document. That might represent an error in law sufficient enough for the judiciary, the court, to find there's been an error of law, which is material, and sufficiently material in order to send the matter back for re-examination. So natural justice, at the end of the day, at both levels, is everything in these cases. And it's there to protect the rights of individuals because, let's be blunt, there's a power imbalance between the power of the government on one side of this argument and the power of the individual applicant on the other. So it is important that applicants are heard, that all their materials are considered properly, and any deviation from that represents basically an error in law.
Yes. Can I have the next slide, please?
Agnes, I have a question
Yes.
in relation to merits review.
Yes.
So my question is that the ART may remit the matter back to the department.
Yes.
And how long does it take for the department to come back to the visa applicant in relation to the visa, whether it's approved or refused?
Okay, very good question. And my answer is not so good because we are at the mercy of the department. The department has a so-called, not under the law, but a general practice. They have 28 days.
Okay.
But that doesn't apply to them. Okay. So the issue is, it is up to you as a representative to go back to the department and constantly, asking them, can we have a final decision? Could you please review the documentation, request something, okay? So as a representative, you can facilitate this. But, I have clients throughout our 30 years when the department has set on a decision for about 9 months, okay? But then generally speaking, is about within 28 days, they coming back to you. But you cannot force, there is no legality to say, oh, you need to make this decision, okay? Now, sometimes you may be able to go to the ombudsman and say, this is very unreasonable, that the department doesn't necessarily, you have nothing to lose, okay?
Yeah.
I mean, you seek support from the ombudsman. Hey, this is far too long and we would like to finalize this matter. Could you please support us with the department?
Okay.
The ombudsman may say yes or no, because it's up to the department. Say right now, if we have, for example, a request for, it's not a tribunal matter, but just as an evidence how the department is dealing with times and time limits. We have made an application for a refund on behalf of the client, and we have $6,500 with the department since March, right? Now, in any reasonable dealings, you write a letter and you request the funds, and the relevant body is returning your money. Because, you know, the in this situation, the sponsorship was refused, and they given the opportunity to the visa applicant to withdraw. And of course, the visa applicant is able to claim that fund. Immigration sits on it, okay? So now I'm at the point that I'm going to write to the ombudsman and say, this is unlawful. The department is unlawfully holding on to our money. But again, this is just, you really don't have a time limit to seek the department to make a decision.
Okay, thank you.
Yeah. Was there any other question?
No, all good so far. Thank you.
Okay, all right. Thank you so much. All right. So in this slide, you know, briefly we talk about procedure fairness. So Heinz, if you would like to further, elaborate on procedure fairness.
This is the slide in front of us.
Yes, the slide in front of us. Yes.
Yeah. So again, it is about making sure that it gets all of the information before it that one has. The point on the first part of the slide there is that if the tribunal relies on something that it doesn't get from the applicant, it must give the applicant an opportunity to review that first. So that's natural justice, and it's about transparency and making sure that things aren't being decided on where one party hasn't had an opportunity to at least deal with the issue and explain that issue to the tribunal before that decision is made, because obviously an issue might have very different interpretations between each side of the argument, and the tribunal's got to consider not one side but both sides before making a final decision. Interestingly, sorry, Agnes.
No, go. Yeah, thank you.
Do you want me to talk about decisions without a hearing, or do you want to deal with that?
No, that's fine. That's only relevant to the tribunal. And as I discussed that before, the tribunal is now supporting that they can make a decision on the paper. And as I mentioned, your submission has to be watertight and has to be very convincing. When you appear to the tribunal, we have a very good base, because you can find a decision, from the department. Why did they refuse that? Now, maybe here it's very important to mention as well, when you have a visa application refused, you only require to focus on the decision in question. Okay, so if they're refusing a partner's visa, and I'm using a partner's visa, if they're refusing a partner's visa because there is no genuine relationship established, then the tribunal can only focus on that part of the legislation. So say if there is a character issue, the tribunal will bring up a character issue. They can't do that, okay? So they can only review the decision, okay, in question. However, when you do an appeal in a sponsorship or in a nomination, so especially in employment situations or some other situations like where you have to say at 850 the sponsorship has been refused, the whole matter has to be reviewed again. Okay, so you can present new evidence, and the tribunal have to look at the whole nomination again. So in that situation, they have to look at the LMT, they have to look at the salary level, they have to look at all aspects of the nomination as well as the sponsorship, all aspects. But you can provide further evidence, and you can provide recent court decisions. That's why it's very important that us as practitioners are reading and be familiar with recent court decision, because as you all know, the tribunal can take into consideration court decisions. So, for example, we had a 494 visa refusal, a regional, as you know, and they refused that, the nomination wasn't correct and the nomination is, we did the application. And I said to the client that possible that the department will refuse the application because the visa applicant previously was refused, blah, blah, blah. So anyway, we went to the tribunal, we represented the client. And we have provided so much information, and the member was so amazing. Okay, and sometimes you can have very good tribunal members and not so good tribunal members. And sometimes tribunal members can be a little bit biased, okay? And I'm sure you all came across with that. But in this particular incident, the tribunal member actually went above and beyond what we have provided and provided information regarding the race and fair work information about wages, about what is the employment rate in Australia. It was absolutely unbelievable. So that was above and beyond what we have provided to the tribunal, and we have a successful outcome, and the nomination was approved. Therefore, the visa application was approved. So these days, this client now a citizen and running 3 or 4 shops. It's they're running a very successful business. So I think it is extremely important that you, when you present a submission, you really utilize recent decisions, and also something very important when you represent clients at the tribunal, that you use other jurisdictions as well. So, for example, I had a client where the nomination was refused. That was about restaurant manager. I think it was one of the coffee chain, and they refused the nomination. And we used other jurisdiction in that sense. We used the work cover space, and we also use the taxation space, because the business was approved as a coffee shop. Immigration argued that this is not a coffee shop. So the taxation was also, we had documentation that it was registered as a coffee shop, and also work cover and the classification was also as a coffee shop. So just remember, then when you're representing clients in nominations or mainly nomination, and prove that the position is genuine and the business is offering this type of services, you can always go to different jurisdictions and argue, because if one jurisdiction, like the Australian taxation rule, is accepting those evidence and they are registered under that rule, the department has to accept that as well. So in this particular case for my client, we used the classification of work cover, and we also used the taxation ruling that the place is a coffee shop and not a fast food. So we got the nomination approved and the visa applicant got the visa approved. Okay, so these are the additional information what I can mention regarding the tribunal appeals. Okay, as I said again, they are all on paper, and also something very important, that the tribunal will have all the documentation from the Department of Home Affairs, but you also should seek the documentation under the FOI from the tribunal, because then you can see what the department has submitted to the tribunal. So there will be no inconsistency when you're making a decision. Yeah, there is a question, Jackie?
Yes, there is. So if an application was refused based on not meeting the English or other single matter, the tribunal process would only address the particular issue only. Is that right? Rather than the whole Schedule 2 of the visa again.
that if the visa was refused because of no English, that is only reviewable. If the English is required at the time of the decision, then the tribunal can review it. If the English language test is required at the time of the application and the applicant hasn't submitted, then you have no argument, okay, because at the time of the application wasn't submitted. But if it's at the time of the decision requirement, that's all what the tribunal needs to focus on. And also you can seek a priority assessment when you provide the English language test. Also the similar situation when the applicant forgot to provide to the visa application the police check, right? But then they have it, and they have it at the time of the application. You can just provide it to the tribunal and seek a priority assessment. Okay? But the important issue is if it's at the time of the application requirement, it doesn't matter that you go to the tribunal and you want to argue it on English language merits, because if that's not at the time of the decision, then it's nothing to review, okay, because the applicant didn't meet at the time of the application. Am I answered your question?
Oh, Stacia? Is that something? Okay, all good. Thank you, Agnes.
Thank you, thank you. Okay, so that's very important. So you ask the whole material from the department, but you also, ask the material from the tribunal and check if we have all the relevant documentation. Remember, it could be that during the process of the ART, maybe the ART becomes aware of some adverse information about the relationship. Say, sometimes you have, I'm sure you all heard of this, that someone, the neighbor has they dobbing in the visa applicant. No, they are not in a genuine relationship, blah, 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 blah. Then in that situation, you must seek evidence from the tribunal. That is called a certificate, okay? And you must seek that certificate, and the tribunal must bring the details, okay? They might not gonna give the third party name to the visa applicant, but they must bring the information to the applicant at the hearing, okay? This is what has been said. This is what can you say about that, okay? Question, yes?
No, that's all
There's
good.
a conversation going on, Agnes, with an interesting issue which Arun has raised about a lot of applications at the moment. A lot of applicants are using artificial intelligence to lodge their own applications, and they're basically self-represented. And I'll just make, if you don't mind me
Please
stepping
do so.
in,
Yes.
can I tell you that all courts at the moment are wrestling with this issue of AI, and that people are using AI to try and, if you like, cut corners to get their applications before the court in a form that will be accepted. The courts aren't happy about it. The tribunals will not be happy about it. There will be, you can expect that they will be jamming down on this and making it more difficult for people to do this. There's at least one tribunal I know about in a different jurisdiction that's actually complained to the government that they're getting swamped by AI applications, most of which make no sense. And it's actually interfering with the court's productivity. So I think, Arun, this might be a short-term problem. I think the courts will sort it out. But at the moment, I agree with you. There's a lot of AI applications and people trying to do that themselves. It's just a short-term thing. It will be dealt with.
What was the last question, Jackie?
There's no question. They're just talking about validities issues that refers to Schedule 1 rather than Schedule 2.
Okay, no problem. Okay. I mean, that's about invalid application, all right? That's nothing to do with tribunal appeal, because you cannot review an invalid application. So there is no merits review for an invalid application, okay? Next slide, please. So what jurisdiction review? It's your turn again, Heinz.
We did this one, didn't we?
Grants jurisdictional. Yes, we actually talked about it.
Yeah,
yes.
we did this one.
Yeah. Okay, there is one thing, if you don't mind, to talk about the originating application once again. That the originating application also has to be filed within 35 days. So
That's right.
this is important because if a visa applicant misses the deadline for a tribunal appeal, which is 28 days, maybe they can still progress to the court and lodge an originating application where you don't require to demonstrate a decision from the tribunal. You only have the respondent as a Department of Home Affairs, and you're lodging an originating application. So that gives a 7 days window, but certainly it will be a little bit more difficult because what in this instance the applicant has to demonstrate that there is legality. So, the decision was so unfair that there is a legality issues. But also remember, when you go to the court, you also have to look at the whole process and the whole application, because it's no point to go to the court if the matter goes back to the department and they still wouldn't meet the requirements for the visa. So it is very important in an originating application that you are sure that the visa applicant would meet the requirements and the department made an incorrect decision and there was a jurisdictional error, they didn't apply the correct law, and therefore, or they applied the law incorrectly, and therefore you can be successful in an originating application. So that's just something very important, okay? So the applicant would have another 7 days to apply to the court. Next slide, please.
Agnes, there's some clarification or question from Nicholas. So what he's trying to ask here is, if the department refused the visa application because of lack of English, and then the ART remit the matter goes back to the department, is there any chances that the department refuse the visa again and look at the other criteria of refusal?
100%.
Okay.
100%. They can look at, because that's all what the tribunal is going to focus on. And if the applicant doesn't meet the other requirements, then they can refuse based on that.
Okay.
But throughout my 29 years practice, I think it's happened to me maybe once, maybe twice, that very, very rare that the department is, because then maybe when they're making the decision, they're reasoning all the requirements and they presenting the decision accordingly, not just one particular paragraph. So if the person doesn't meet the English and the tribunal remits the matter back to the department because of English and all other matters met, then it's perfectly fine. Then the department wouldn't refuse it again.
Okay. I hope that's something that helps you, Nicholas, in relation to your question. I think you can move forward, Agnes. Thank you.
Yes, next slide, please. Oh, yeah, we are at the next slide. Thank you. Heinz?
Yes, so again, this was what we talked about earlier about error of law. It's about testing for a jurisdictional error. So has there been a failure to provide natural justice? Has there been a document not submitted, something not taken into consideration that should have been, something that's material enough where it may have caused a different decision to have been made had it been considered, and that error then means that it's material and can be reviewed. So the criteria is, could it have been realistically, it's not about showing that the error would have resulted in a different decision. It doesn't have to be that certain. It's, does that error, if taken into consideration, could it realistically have changed the decision? And that's the materiality test. So it's not as high a threshold perhaps as you may have thought it was. Errors often are made. Sometimes things are not considered that should have been. And if that can be shown to have could realistically made it caused a different decision to be made, then that's a big enough materiality threshold for the court to remit the thing back to the tribunal for a review. So that's the natural justice test for jurisdictional error.
Jackie, question?
Yeah, so Nicholas is asking whether the ART would refuse. So I actually answered that question. ART can only remit the matter if there are grounds that the visa applicant met the criteria, but the department is the one making the decision.
Absolutely. The tribunal can, remit the matter back to the department, or they remit the matter back to the department, but the department will make the final decision. So you are always at the mercy of the department, of the tribunal hearing. Now, if a nomination set aside and returned to the department has to approve the nomination. Okay? So when the tribunal set aside the decision, then it has to be, the department has to approve it. Okay? Because then the tribunal, as I said, they look at the application as a whole again, and therefore the applicant met, or the nominator has met, applicant under the review met all the requirements of the particular nomination. But if the matter is remitted back to the department for further consideration, that's what they say, okay, which is correct. As I said, could be certain other elements that they didn't meet, then they can refuse it again. Okay. So therefore, it's important that when you represent the client at the tribunal, you make sure that all the other elements has been met when the matter will be remitted back to the tribunal. I've worked in the past with some colleagues of mine who are barristers. He wouldn't take on a court appeal, even if there was jurisdictional error, because the applicant wouldn't meet the rest of the application. So he said, they're paying the money for the court, but then they're never going to get the visa. So it is very important that you look at any decision and any application holistically, and you look at the whole decision or the whole application with finality on the end. Okay, is this going to be approved, or is this not going to be approved? Okay, so next slide, please. So these we already talked about this as well. Section 333 of the Migration Act. That's part 5. What are reviewable decisions, and what is not reviewable decisions? So as you all know, the conclusive certificate which issued by the minister, and this has been introduced because of Section 541, this cannot be reviewed. Okay, so it doesn't matter that the client says this and the client says that, but I am here, but I am there. We had clients who lived in this country for 60 years and they turned him to England because the minister issued a conclusive certificate regarding corrupt lapse. So that is something very, very important. And the minister is using that very frequently, to issuing the certificate. So that is not reviewable. Next slide, please. So this is about privative clause. And that was introduced, I don't know how many of you practiced as migration agents in the early 2000 when Rodok was as a migration minister, and he introduced that under the privative clause, no migration decisions can be reviewed by the court. And of course, it went so far until the High Court threw out that, decision and reintroduced that, migration decisions can be reviewed by the court. Okay, so that's important. Next slide, please. So Jackie, do you want to talk about this slide, please?
Yeah, sure. So this is where you actually need to call a lawyer in relation to your matter. So if there's any prospect of judicial review, RMAs cannot be able to represent in the court, and this is something that you have to engage a barrister or lawyer to represent it. So if there's any grounds that you're not 100% sure about that, just feel free to reach out to us. That's something that we can be able to assist you. We have a bunch of migration lawyers that can be able to help you. So any character cancellation or Schedule 3, that is actually issue about the credibility about the refusals. That's something that you can be able to reach us out. Any tribunal error, as Heinz said, we can be able to address this matter. Probably look at the error of the law or something like that. It's best to get an advice from a migration lawyer who can be able to provide you a legal advice in this matter. So as I've said, anything that, any migration agent can be able to reach out to us pertaining to all other matters that you're not sure of. So yeah, EJ, next slide, please.
Yes, in this slide, we talk about a couple of decisions, recent decisions of ours regarding student visa refusal, regarding employer sponsorship, under a family-sponsored visa, and also regarding a partner's visa. Actually, recently we had a very good tribunal decision that under the department refused the partner's visa based on 4020. And as you all are aware of, this is misleading information, and having a bar of 3 years to apply for another visa. We were successful to argue at the tribunal that there was no incorrect information. There were information which provided to the department, which were not inconsistent, but maybe it's a pair that the person has two relationships, and one was just a friendship and the other one was a leftover from a previous relationship, and then the new relationship was already in force, and therefore the relationship was genuine under the new application, and the tribunal approved the current partner's visa application. I just would like to share with you one of our very good decision, which was also a tribunal decision. We have a number of court decisions where we have jurisdictional error by the tribunal using an incorrect and audited ENSCO dictionary. I call it a dictionary. And we were successful at the court to argue that due to this was an incorrect document which was used and never should have been used in this decision, because under the different ENSCO description, depends which year different description appears. So, and that's when we got the court decided that yes, there was a jurisdictional error because an incorrect information was used. The matter was returned back to the tribunal, and the tribunal on the end approved the visa for the client. But also we have a number of tribunal cases where, again, say a number of years ago, we represented the client in a regional sponsored visa where the visa applicant worked for the university in a regional area as an animal welfare scientist or whatever. He was looking after the local wildlife. She was from the US. She didn't really require high salary because she was receiving a good income for the US. So the university provided her fringe benefit in a way of accommodation, phone, car allowance, all that. And as you all know, in a regional sponsored visa applications, you must seek an RCB approval. And the RCB, the local RCB body, has approved the nomination, and we lodged the application. And the department came back and argued that the RCB decision to approve the nomination or approve the RCB nomination, that was flawed, and they wanted a fresh RCB application lodged and get a new approval from the RCB. So the RCB came back again based on the same information and said, no, we approve this. You know, the client is receiving income because the client is receiving, or the visa applicant is receiving fringe benefit in a way of accommodation, blah, blah, blah. So that's amounting to $50,000. At that time, it was $50,000. So we relaunched the application again with the department, the RCB nomination approval, and the department wouldn't make a decision. And again, here it comes, what time limit the department has. They were sitting on the application for about, I cannot remember exactly, but well over 6 months. When I decided that we emailing to the department and telling them that we're going to go public with this whole process because this is very much unlawful what they're doing. And we just would like to have a decision. We don't really care, is it a refusal or a grant? Of course, the department has refused the visa within 1 week. So we took this matter to the tribunal, and the tribunal has approved the application because based on a court decision, fringe benefit is accepted as an income under the Australian taxation law, and therefore it should have been accepted by the Department of Home Affairs. Because the tribunal can take into account different recent court decisions, we were successful. The matter has been returned back to it actually has been remitted back to the department with this particular paragraph has been met, and the department has granted the visa to the client. So it is very, very important at tribunal level that you are very familiar with recent court decisions, and therefore very important that maybe you seek the support of a lawyer, who is experienced and can advise you on legal issues. Even if you guys just seek, initial advice, that is very, very important.
Okay, Agnes, there's one question from Teresa. She's talking about the subclass 407 training visa, that the department refused the nomination, but majority of it, visa applicant received S57. So what's the best approach on that one?
Why was the nomination refused?
Usually, probably is a general template for the training plan.
Yeah, but what I would like to have is get the nomination appealed against. The section 57 of the department can refer to what the visa applicant would like to do, appeal or withdraw, okay? If you have a good standing under the nomination, I would appeal the refusal of the nomination and then appeal later on the decision for the visa refusal.
Does that make sense, Teresa? Is that something that answers your question? Okay. Probably it's gonna be a yes, Agnes.
Okay.
I'll come back to you if there's some questions around that.
Yeah, okay, next slide, please. Yes, now here we are again at question time. So if you guys have any question, and Teresa, is the answer what I have given you is something what you were looking for, or you're looking other alternative?
Okay,
What was the?
so what she's saying is if the nomination, so if the employer appeal the nomination, can the visa applicant ask the department to defer the decision? So what she's trying to say
No
is
deferring, there is no deferment of
deferment. Okay, cool.
No, 28 days, and they don't defer the decision.
Okay.
The decision can be made, 28 days after they made the decision. Okay, 28 days after they sending the RFI, which is the section 57 letter. So 28 days after, they're gonna refuse the application. You have the right to withdraw, or you have the right to get it refused. No deferment.
So one of the comment is they saying let them both refuse, so nomination and visa, and appeal both of it.
100%. That's what I recommended as well.
Okay.
I mean, there is a, if the person is on a bridging visa, okay, and this is just something what we sometimes can do. If that process of the 407 has taken a long time, okay, maybe 8-9 months, and the visa applicant was able to collect 12 months full-time work experience in the position, then maybe if you have the 28 days plus 28 days, okay, that gives you good 2 months, you can do an LMT, and the company can sponsor the visa applicant on the 482. So if you just receive the refusal of the nomination, provide the 28 days based on the RFI. At the last day of the 28 days, withdraw the application because the visa applicant actually would have 35 days on a bridging visa. And because the applicant would not be refused, that applicant would be able to apply for a 482. We done it actually for a motor mechanic, very much like that, and applied for a 482.
Okay, so there's another question that BK asked is about the not meeting the health requirement, PIC 4005. How does the tribunal look at this matter?
Okay, the tribunal can look at the matter of 4005. There are a few court decisions on the 4005, but very limited. If you don't meet the health requirements, usually the tribunal won't be able to facilitate a better outcome. But it all depends, what is the cost, and if the cost, the department came, or it's called the medical officer of the Commonwealth, the MOC, if they came to a wrong conclusion, how much would be the cost to the government? Because as you know, there is a limit, I think 80,000. It's always changing. So, but my recent recollection is 80,000. If the fee is calculated incorrectly, maybe that can be reviewed. But if there is a $250,000 cost to the Australian government, very, very, very unlikely that it will be granted or approved by the tribunal. And I must say, the minister has made a new ministerial direction last year about the review of when you can take a matter to the minister for further consideration. And I am not 100% sure, I haven't looked at that recently because we don't do too many ministerial intervention. If there is a right to take the matter to the minister to further consideration and grant the visa to the applicant, even if they don't meet the medical requirement. Previously, we used this as a vehicle, and in one instance, we were successful. The minister has granted a 10-year visitor visa for a client who was in a hospice. Unfortunately, the client died in about 6 months later, but the client was able to stay here. Next question, Jackie.
So Teresa is just asking about if the nomination refusal is already in ART. I think you've already answered this question. Will the department pursue refusal? So I just answer it back. It's still gonna be refused 28 upon receiving S57.
Yes. If the matter is at the ART, doesn't matter, there is no delay, you can't seek a deferment of the decision.
Arun, can you please explain that further, please? Because you asked about if, say, hearing is corrected in child before a tribunal decision, case remitted under PIC 4005. I'm not sure what do you mean by that. If you can please expand your comment on that one, that would be great.
What was that, Jackie?
So he's just commenting about the hearing is corrected in child.
4005, yes.
4005. So there's no questions in there. Probably it's just a comment. Okay, so very interesting question from Nicholas. So what would the average cost of going to the federal court fees and professional fees?
Of the hearing, also whether you brief a barrister as well as a solicitor or just a solicitor. But normally you'll get your rates from your solicitor. There'll be an hourly rate. They'll give you an approximate time that they think they'll be in court. And you can budget normally on a court case that for every day of a hearing, they'll spend 2 days preparing. So let's just say you've got a 1-day hearing, then budget for 3 days of fees. And that'll give you some idea of the range of fees that you might be looking at. The court costs obviously go to the court and stay there. The professional fees will be a product of the rates that you're charged and how long you'll spend preparing and actually being in court. As an average, Agnes, would you have some idea of what an average might be in terms of fees?
Yeah, it's usually a court appeal with representing the client through our lawyers, experienced lawyers. You're probably looking about $10,000 to $12,000 to go into the court. If barrister is required to appear, then the barrister is usually charged to appear at the court is another $8,000 because they need to do the appeal, Sometimes can be depends on the severity and complexity of the matter. And as Heinz said, it depends. Is it a 1-day hearing? Is it a 2 days hearing? Sometimes could be depends if there are any witnesses called, if it's required. Usually in court appeal, there are no witnesses. On very rare occasion, get a witness, or maybe the department is called, to give evidence. But yeah, it's usually about 1 day, and that these are the fees roughly. So if a barrister is involved, maybe you're looking about $15,000-$16,000 for the fee.
The good thing about it is that an appeal is generally a very narrow argument. It's usually on a very small part of the dispute. It'll be about not taking into consideration a document or an issue or something. So the hearings are generally reasonably short. They don't extend for days and days and days like traditional trials might in a matter on the merits. So in that sense, it's not as expensive as you might have thought, but still it's a lot of money in the overall sense of things, and you're right to budget for it.
Okay, so there's one more, Agnes. So when an applicant lodges a judicial review application in FCC for a migration decision, how long does it take for the bridging visa to be linked?
Very important. 2 things, very important. If the visa applicant holds a BVA, okay, you must send the documentation into the department and seek the extension of the BVA. It's not an automatic process. The court, when you appear to the tribunal, the bridging visa will be automatically renewed, but this is different with the court, okay? Same thing if the applicant is on a BVC, you have to notify the department that the appeal has been lodged, and they're going to extend the bridging visa C or bridging visa B. Whatever bridging visa your client has, you must notify the department that the application has been lodged with the court.
Okay,
and the visa can be granted probably. We just have recently a client where we did actually it was a different story. The client was at court appeal, and we lodged a 494 because, as you all know, a 494 can be lodged onshore even if the visa was refused. And the bridging visa C came through in about a week or 8 days, something like that. So it doesn't take that long.
Okay. Yeah, and one of the questions as well from Baritinder, that he or she heard that the federal court registry can now refuse the judicial review if there's no merits for review. Is that correct?
They won't take Heinz?
Say again, sorry, Agnes.
So,
So the question is if there were no merits, so there were no tribunal decision, that's what you're referring to?
so if they apply in FCC, for
Directly,
judicial,
it's an
yeah,
originating
correct,
application.
yeah. So can they be able to refuse that straight away, before it
So
goes to the
there,
judge, or there's a
there is
procedural fairness for that one?
it'd be unusual to refuse it straight away unless the judge has formed that view and told the
Okay.
registry to do that. But there is great discretion vested in judges on things like this. I'm not aware of any precedents like that. Agnes, are you?
No, not me either.
I think it'd be a highly unusual circumstance, and there's a good chance they would bounce it before it ever got into the court.
And also they may, haven't provided affidavits in the right way, haven't uploaded correct documentation, and then they sending it back immediately. But usually not because of the merits. Okay, the court doesn't look at, as I said, originating application also has to have a legality. So there is some error by the decision maker of the department. Okay, maybe they didn't take into account some evidence, or maybe they taken into account the wrong evidence, they didn't ask the right question. So then you have right to appeal, just because, there were some evidence not provided, or the department made a decision. I mean, it should be an originating application should be always accepted by the court. And the process is, once it's accepted by the registrar, then it goes to direction hearing usually, and then it goes to the proper hearing, okay? And then the judge is going to review it.
It assumes the originating application is in the proper form. And it's like that earlier question about AI. If they're coming through without the right information in them, then it's potentially problematic.
Exactly. Then the registrar wouldn't, it comes
Wouldn't
back
accept it, yep.
Same day or the next day, and they refund the application fee.
Okay. Just the time check is already 1:30. I think Nicola's question would be the last question that we're gonna take for today. But I'll be providing you with some information on how you're gonna contact us. So last question is there any seminars or CPD on researching case law in migration in the AI era, both ART and Federal Circuit matter? Are you aware of something? Okay.
Yes, we can do that. We have a number of, and we can do that as well ourselves. We can run a webinar or a workshop regarding that, because we are all principal lawyers and our presentation are approved by the, what you call the Law Society. But also we have a close friend of ours, Barrister Lorenzo Boccabella, who also runs workshop, regarding court decisions. And this depends, what type of area you would like to have information.
Okay, all right, thank you. So on the screen, we have the QR code right there. Please feel free to scan the QR code, book a 20-minute free consultation. I'm happy to go through with you and book, consult with one of the senior lawyers or principal lawyers that we've got. I guess, thank you for joining today. Thank you, Heinz and Agnes, for an insightful discussion. I really appreciate for everyone's time for participating on this webinar. And I hope that we have given you a clear understanding of what to expect, and we will be providing you with some resources as well. So thank you again for the participation and engagement. It has been a pleasure hosting this session, and I look forward to connecting with you again soon. Have a great afternoon. Bye.
Thank you all.
Thank you, everybody.
Bye-bye now.
Bye for now.